All right. I tried to save this. I'm struggling a little bit. There's an update for my software, and looks like it's still trying to save this thing. Let me just abort this. All right, what I'm trying to get through, I recorded this once, and I'm hoping I can record it again. We're going to walk through how to do this case, the case analysis. I have some risk of I will confuse you further. It seems like every time I talk to you students, you get more confused rather than less confused. And so, I want to walk through this one more time. If we look at, so let's begin with the assignments itself. Please notice that the facts are worth 15 points. The explanation of the plaintiff's case is worth 20. The defendant's case is worth 20. The court's reasoning and judgment is worth 20. And the student's final analysis of everything is worth 20. So to do all of this, you need to follow the outline that I prepared at Amanda's urging. And that is make sure that all the facts show up in your statement of facts. Then the next part is we're going to look at the plaintiff's case. Now, this is a little confusing because in the Supreme Court of the state of Missouri at the time, they described Eaton as the plaintiff in error. In modern courts, that's known as the appellant. And so he's really the defendant at trial. And what I'm looking for is Vaughn is the plaintiff and Eaton is the defendant. So as you're writing these, look for that carefully, okay? As we went back into, we go back up into, you can see the arguments, Adam and Hayden for plaintiff. In this case, that means Eaton. That actually means the defendant. And he didn't do much. He basically addresses two of the issues. One is just the negligence component, and the other is damages. So, I guess actually he addresses all three, because what we're talking about here is we're going to look at the negligence in permitting the slave onto the boat, the value of the slave, is he really worth $500? That was a lot of money back then. And then smart, our modern phrase is punitive or punishment damages. This is hey, wake up and smell the roses. These damages are, this is meant to teach you and others like you a lesson. Don't do this again. And so I'm asking you, try to state what the plaintiff, Vaughn's legal arguments are. And flipping back again, we can see that Vaughn's lawyers put up a lot of arguments, and you're going to find this language mirrored in the case. When you look at the arguments which show up more at these points, this is where the court analyzes it, and they look at the case of Tyson versus Ewing. You can go back up. Is Tyson? I'm not sure Tyson. Yeah, here's Tyson versus Ewing, utilized by this court, and it looks like maybe John Marshall might have written that opinion. I'm not dead positive. These citations are a little bit, these are really old. I'm not real good at this, but 7 Vermont rulings, 63. He cites a lot of cases here. I don't expect you to go in and read them all. I want you to be able to try to state them as clearly as you can, based primarily just on reading the court opinion. Maybe it's a good thing I wasn't able to save the other one, because a student wanted to focus on all these head notes. And the head notes are great if you're a lawyer. They're almost an outline of the statement of the case or the statement of the law. They're nice, quick, dirty section statements of the law. What I want to see is, how did the court get there? How do we know that this is sound law? When we look at this pronouncement of law, is it based on sound reasoning, or is it based on executive fiat or judicial fiat? And fiat means just, we say this is right, therefore it's right. It doesn't say, here's the opposing argument, here's some other arguments that weren't raised, here's some arguments we thought about while we discussed it. Ultimately, we come to this conclusion, and here's why. That's much more supportable long term. It lets those of us who have to apply the law recognize how the court got to that, and sort of helps us, because the law isn't necessarily meant to be absolutely rigid. It's meant to have a little bit of flexibility, a sort of reasonable compound. So, don't focus on, I've got to explain every one of these head notes. They're explained in the case. What I'm looking for is the deeper, this is exactly what the court meant by this, or this is what I conclude is correct. Okay? And I want you to look at, are there any reasoned counter arguments to this party's positions? That's a challenge with the plaintiff's case. They seem to be pretty right on the law, even though we wouldn't agree with the law now. We have to recognize that back then slavery was an institution, and that Missouri came in as a slave state. That's part of the Missouri Compromise of 1820. Our statehood is 1821. We're coming up on our 200th year. So then we're going to look again with the defendant. What are the defendant's legal and factual arguments supporting its positions on negligence, value of slave, and smart damages? They don't give us much, and there's not a lot in the case, but I want you to do the best you can with what you've got. I also want you to consider whether there exist plausible arguments for reduction in damages due to the slave owner's known negligence relevant to keeping the slave on the population. Is it really the boat owner's responsibility to make sure that runaway slaves are returned? Or, if I leave my, it's not the same, but if I leave my power tools sitting out on my driveway and someone steals them, is it my neighbor's fault that he didn't say, hey, what are you doing stealing Bailey's power tools? I might have left them out for that guy to come and take them, for all my neighbor knows. Anyway, that's not a very good argument. But, were there indicators prior to Charles leaving the plantation that he might be a runaway? You might be able to extend this argument to value. A slave that's likely to run away is worth less. I think we can make some kind of argument that, we're not going to pay it full for him. It also maybe talks to, this isn't the right person to be awarded smart damages. This slave owner didn't take adequate care of his own property to now make this a case where the ship captain is responsible. I think the rest of this is fairly clear. There is one thing here that you may not understand in individual analysis. When I'm talking about the waterway railroad, that's an obscure reference to the Underground Railroad, or the way of escaping. I have a supposition that the Wapello was well known in the rumor mill among slaves as a ship that, if you could get on this one, the captain doesn't check your papers very well, and there's plenty of opportunities on the trip, and it goes all the way to St. Louis, and you can get off in St. Louis and you can disappear. It's a big town. There's a lot of free and captive slaves in that town, and once you're there, you're free and gone. Illinois is, there's boats that'll take you to the island in Illinois, and you're gone. Um, I throw some other things you could talk about. Smart damage is a valid tool when applied in individual cases. If you're going to award punitive damages to somebody, um, why do they get a windfall? Why don't we create? It's one of the problems with punitive damages, and it may be something we can't resolve. But why does this guy, the fruit grower down in Cape Girardeau, get a $40 million award against Monsanto, and it may have been 80 million? That's a huge amount of money, and it's probably why most appellate courts drastically reduce punitive damages awards. They find a way to say, well, this has already been published in the paper, and its punitive value is diminished, and it becomes a windfall for individual plaintiffs or a windfall for individual attorneys. Um, I like the idea I have here. You know, could we look at this case? Maybe should have been sent back down to the trial court for them to go over the smart damages as well as the value of the slave damages. Um, and then finally, I want you to kind of look at, what do you think the presumption is with a modern shipper? Do modern shippers think that everything is lawful, or do they have a duty to go in and scan everything and see exactly what's in it? You go to the U.S. Post Office, they ask you a couple of questions, and then they pack it up and they ship it. Is that where we ought to be with shipping? Um, you know, I think they routinely bomb sniff them, but beyond that, we're going to presume. And if you look at our modern shipping, why shouldn't we? But just spend some time looking at, you know, might this apply to modern shippers? Because the law announced by this court is very similar to simply saying that, this is almost strict liability. If a Negro presents himself on your boat, you presume that this person is an escaped slave, even if they have the papers of a free slave.